We've now got Damian Honey and Hugh de la Forge from Holm Phoenix, who are going to speak about energy disputes in MENA. So over to you, Damian and Hugh.
Thank you very much, Derek. Good morning, everyone, and it's great to be here in Qatar. I'm actually here with quite a large Holman contingent because Hugh is here, also Match Vichko over there, Michael Sargent at the back, and Rob Blundell over there, all from our construction team. So please feel free to talk to them. I'm actually going to be talking about energy disputes in the Middle East, North Africa region. And there's always a problem with doing slides a few days or a few weeks in advance of a conference, because particularly in the commodity world with the volatility in the prices, there's so much fluctuation that immediately after one day you've written the price, written the slide, you're easily out of date. Now I'm sure we'll have all seen over the last couple of days that the Brent price has almost risen to $50 a barrel, which has made Goldman, for example, one of the more bearish banks, a bit like Standard Chartered, suddenly revise their expectations about where I hand over to Hugh. And I'm a bit of a time fascist, so I'll stick to that. I'm just going to be looking at oil and LNG, particularly here in Qatar. Obviously LNG and gas are of huge importance, and certainly we've seen a huge growth in the use of LNG. I don't know if you know, but very proudly in the UK, in the last week or so, the UK has effectively produced power without reliance on any coal. And there's a huge move away from coal and a huge rise in LNG, and I think that's obviously very important, and why Qatar is going to grow in importance in the global economy. So just my slides talking about where we are in the oil market and why we've got these disputes. Well, ultimately, early 2016, Brent hit the low of 27.67. It's now almost doubled in size in terms of price, up to nearly $50 a barrel. That's why a lot of the oil majors are announcing that their profits aren't as bad as they thought they were going to be, because they've got huge trading divisions that like BP, Shell and Exxon, who are able to take advantage of this great volatility in the pricing of oil. Why has it risen? Well, there's quite a lot of outages in the market at the moment, particularly in Nigeria, and where there's been some supply issues and greater demand issues perhaps coming from India rather than China, with the consequence that there's huge variations in the price. And why does that matter? Well, imagine if you fixed a supply deal with someone at a particular fixed price, and still fixed pricing contracts are quite common at, let's say, $30 a barrel, but actually you can sell it in the current market at $50 a barrel. Are you going to try and get out of that contract? Yes, that's what happens. Just a slide there giving an indication of where the markets are going, but obviously they're now starting to come back in an upward curve. Just looking now at then oil disputes, how they arise and how this links with arbitration. Generally, the oil market in the region is significantly more mature than the LNG market. Oil market disputes are relatively, in that fact, fairly common. How does arbitration work? Well, it does vary quite significantly. A lot of the crude offtake contracts are still done under NOC terms, National Oil Company terms, and it's very highly likely that those contracts, if there is a dispute, will have court jurisdiction provision. Why? Well, ultimately, the issue that arbitration has often had to face in the past is that it's the constitutional right of an entity to go to their local courts to have a dispute resolved. And certainly if you're dealing with an institution, a government institution, that's what they will require, and that's something which is simply not negotiable. So that's an offtake contract where you've got a long-term offtake of a crude supply. Where you're trading that commodity, it does vary as to whether or not arbitral provisions are going to be included in those contracts. And if you look at the BP or the Shell or the Exxon or the Total provisions, they're all different. Why are they relevant? Because those terms are often the terms that are incorporated into those contracts. BP and Shell, for example, still refer to English court and English law. there is an option to choose arbitration, and that is increasingly taken. BP terms, the most recent of which are the 2015 terms, are becoming quite popular in the market at the moment. For those of you who just want a bit of background, the BP terms have been amended in 2015 from the terms which originally were in existence in 2007. Shell also amended their terms in 2010, and their Shell terms of 2010 compared to the BP terms of 2007 are quite similar. And so there's increasing standardisation in the market, which is good for the market. Equally, it's good in relation that some other terms are adopting general terms which are adopted by BP. If you look at the production contracts, these are obviously very bespoke. There isn't as much standardisation, but in our perspective, they are generally chosen to be choose arbitration provisions in those contracts themselves, i.e. those dispute resolution mechanisms refer to arbitration. Which arbitration? Which jurisdiction? One of the great things about international arbitration events often is that it's a competition, it's a competitive environment. Each country wants to attract arbitration provisions and disputes to their city. And I think the Sydney arbitration institution has the best advert for it, because it shows the price of oysters in various different parts of the world, in all the great arbitral cities such as Paris, Stockholm, London, Dubai. And of course, where can you get 12 oysters for the cheapest price? In Sydney. So if you want an arbitration, go to Sydney. It's a long way from anywhere, and I very much doubt anyone from Sydney has made the trek here to Qatar for this event. But what you actually do see is the competition in choices that you have, and cities are trying to get you to go to their location. You see that in production contracts as well. It's bargaining power. Where will we go? And obviously, Qatar is promoting itself as an arbitral centre, and it's a great arbitral centre, but there are others as well which are competing in the market. So just looking at current disputes, volatility drives disputes. So an example being where you've done a spot deal for a supply of a particular product, whether it's gas oil, whether it's fuel oil, for a fixed price, and then the spot price falls before the delivery of the oil, leaving the buyer in an expensive contract. That then leads to a dispute. Or alternatively, the buyer's counterparty becomes insolvent, so therefore the buyer who's on selling, so it's long on its sale contract, but still has an obligation to purchase from its supplier. So it's got a contract, it's got to then mitigate and sell to someone else. What is also common in the longer term price contracts, and this is particularly relevant for LNG, where there can be often 25-year deals, is that there's a price calculation review formula which is triggered upon the occurrence of certain events. Or equally, it might just be triggered on the occurrence of a 5-year, 10-year, 15-year term as the contract goes through its life. These clauses are always very vague because they're driven by commercial negotiation, and inevitably they often lead to disputes. And there's been a significant number of disputes around, not just in LNG, but in gas pricing contracts as well, where you look at the terms and you think, can I trigger this clause such that we can then go often to expert determination if we can't agree on a dispute? And therefore these have been quite common. So just quickly then looking at common oil disputes, I'm going to focus on the ones in bold. I've listed a number of them there, but effectively it's failure to deliver, failure to take delivery, insolvency of counterparty, and alleged FN. So what's a failure to deliver type dispute? Well, it's where a seller or supplier fails to deliver oil to the purchaser. Why would that happen? Well, ultimately that's going to happen in circumstances where the seller is in a rising market and it wants to sell the oil or the product for more than it can achieve in its existing contract. What can the purchaser do? Ultimately, it looks at its dispute resolution mechanism. If it's arbitration, it commences arbitration, goes through arbitration, and achieves a result. sues for the difference between the contract versus the market price if it's an English law claim. What we do see, and it was something I picked up in the coffee break, is it's increasingly common where it's possible for parties to do amicable settlement. I'm involved at the moment in an English High Court case, which is an oil dispute, not an arbitration because the parties to the highest court, where they are talking amicably and will reach a dispute and hopefully reach a settlement. And it's something which is very much encouraged in English domiciled and certainly European domiciled jurisdictions where the parties are very much encouraged through mediation sometimes to try and sort out their problems. Failure to take delivery. So this is where the purchaser fails to take delivery of the seller's oil. Why might that happen? Well, this is exactly the situation we're facing for a client at the moment. So this is an oil trader who's based in Dubai, had a 3 cargo contract of fuel oil and gas oil to sell to a buyer in Pakistan. It was for a fixed price. And unfortunately for our client, the price fell, so that the purchaser then decided not to perform the contract and came up with various excuses, such as the cargo was not of the correct specification. And then the best argument, which certainly as lawyers we always quite enjoy, is the buyer in this situation said, there's no contract. We didn't agree a contract. And this used to be an argument that was run in certain parts of the world in the 1990s. Often around the issues of whether the individual who signed the contract had the authority to do so. I once had a defence run against me by someone who was saying, the individual who signed the contract, he signed it, but he was drunk. And he was therefore inebriated, therefore he didn't have the capacity to actually sign the contract. What we then did is that we had a handwriting expert look at his signature to determine effectively that that was not a drunk signature. We also had a picture of that individual at a signing ceremony, which is often quite common, sitting, not looking drunk. I don't know how the judge or the arbitrator was able to form a view as to that, but certainly we had that in the evidence. But look, the issue here is that this case is a classic example of where there's volatility in the market leading to disputes, and so consequently, this is a very common type of dispute at the moment. That's going to a 2-week commercial court trial in London, and if we can't resolve it, the legal costs are going to be very, very significant. But it's driven by a difference of pricing, which leads to a difference between effectively $10 million just on one cargo of gas oil. Insolvency. Now, this is an area in the sort of the trading world at the moment where we're seeing quite a lot of issues, but ultimately a lot of the financing banks are not pulling the plug on their customers. And this is primarily because the asset values in energy markets have significantly fallen. You've probably all seen news stories about divestment by the oil majors, downsizing. That is triggered by obviously the lower oil price in particular, but that has impacted on asset values and therefore impacted upon financing banks, with the consequence that whilst they might have historically in the past said, well, we just can't continue to finance this customer, they are not doing that now because they will immediately take the loss on their books, which they don't want to do. But what happens in circumstances where a party goes insolvent? Well, you then have to look at the terms of your contract. Normally there are what we call EOD clauses, events of default provisions, which will allow you to terminate if you have a party who goes insolvent. So that therefore means you don't have to continue to perform if your counterparty has gone insolvent. However, if you don't have such a provision, the simple fact of a party being insolvent does not mean, certainly as a matter of English law, that you are, have an out in the contract. It doesn't mean that there's a breach. You've got to try and establish a breach another way. And so we're seeing a lot of issues around that at the moment, not leading to disputes, but certainly potentially leading to disputes. And then finally, what we call force majeure. So everyone will have a good understanding of what force majeure or FM is. It will be written into all contracts, whether that's construction contracts, energy contracts. It's a creature of contract. So therefore, you've got to look at what the wording says in order to be able to rely upon it. The case I'm currently working on at the moment, again connected with an energy market, is force majeure as a consequence of the Ebola epidemic in Sierra Leone, where we were acting in this is not an iron ore issue as opposed to a gas oil or a petrochemicals issue, where the mine was shut down as a consequence of Ebola. Was that an FM event or not? But what you also find, and this comes back to the volatility point, is the issue around price majeure. What is price majeure as opposed to force majeure? Can you say that because it's uneconomic for you to perform a contract, that then allows you to walk away to terminate the contract? Answer, no, that's not an FM event, unless it's put into the contract expressly and says that. If you've drafted that contract carefully, you've got that wording, then yes, you can do that. But ultimately, if you don't, no, you can't, and there's case law to prove it. So that's another area where we're seeing quite a lot of attempts around to develop disputes, which are leading to arbitration. And I've got one very similar to that at the moment, where there's an alleged, what we call price majeure, going to arbitration, possibly in the DIFC. Again, we think that will come to an end amicably. Just then, in the last few minutes that I've got remaining, looking at the LNG market. The LNG market is very different to the oil market in terms of the disputes. If you were to look globally at the number of disputes generated by the LNG market, it's significantly smaller. Longer term LNG contracts, and they're longer term because of the financial investment that has to be put in, so therefore to derive the benefit, all the parties are committing long term. Therefore, they're in a long term relationship, so the last thing they're going to want to do is end up in a bust-up. However, the LNG market is maturing, and we are now certainly starting to see more disputes starting to arise in the LNG market as a consequence of the maturity of the market, and also the fact that it's starting to develop a spot market for trading. And you can see it's developing a spot market for trading because of the shorter-term contract lives that are coming on stream. Also, we're now seeing the rise of FLNG, so floating LNG, floating regasification storage units, and what we call tramping floating regasification storage units, which is my last slide at the bottom. When you have a tramping FRSU, it's when it's a vessel which can effectively regas the LNG, but also move, not just be stored in one location, but move around locations as well, which gives it greater flexibility. Just looking at the issues, generally the long-term LNG contracts are drafted with arbitration provisions in, because the key issue for parties in this situation is confidentiality, and that's the great attraction of arbitration in these markets. They don't want to wash their dirty linen in public. If they've got these price review clauses, which all of them will do, they want that to be determined privately. We're seeing quite a lot of that activity, but again, these issues are resolved amicably. Very few come to an actual full-blown bust-up before a panel of 3 arbitrators. Spot trading, and this is what's going to drive, we think, going to be driving the rise in disputes. It's growing significantly. For anyone who knows, obviously, LNG carriers are loaded here in Qatar, and they go off to Japan, they go off to their markets. Those vessels were always on long-term charters. But for the first time ever in the last few months, a spot charter, what we call a voyage charter from A to B, is now being drafted, which shows you how the market is developing and changing. That's just a slide about movements. I've emphasised the fact that LNG disputes are rare. Just in terms of the arbitration locations that are chosen, we generally see historically LCIA, SIAC, which is the Singapore International Arbitration Centre, and ICC rules chosen. We are, however, starting to see increasingly different arbitral institutional rules chosen. DIFC, LCIA is one of the ones that we've seen chosen recently. Just then, issue around what are the types of disputes we're starting to see in LNG. Title transfer, where is title going to transfer? This raises tax and licensing issues. If you pass it in a particular jurisdiction, that means it has tax implications. We've seen a few disputes around that. Now, off-specification LNG, which is highly unusual, but actually we are seeing a bit of it. And this means where you sell LNG of a particular specification, and then on arrival, it's not the correct specification. And this generally arises where new pieces of kit are used. Effectively, when you load LNG here in Qatar, in order to, it's obviously a liquid that is loaded onto a vessel, it has to go through a mesh when it's loaded, goes into a vessel, sometimes a newly built vessel. When that vessel then discharges that LNG into the regas facility at the discharge terminal, whether that's in Japan, UK, Spain, wherever it might be, it goes through often a different sized mesh, which means that sometimes if the vessel is a new build, it picks up particles in the vessel, which are then discharged into the facility at the receiving terminal. And there have been about 3 or 4 disputes around that particular issue. That's just an example of new pieces of kit being used. But the consequences are quite significant, because if you have particles discharged effectively into a regas facility, which can't cope with those particles, the potential damage to that facility could be quite significant. You can then put into the contract, you can draft around this, and people are starting to do that now, in terms of putting treatment caps in, how you deal with that, with the consequence that some of these, for any of you who've ever seen some of these LNG agreements, they can be 250 pages long, trying to predict every single eventuality. And that's, I suppose, for disputes, personnel, disputes, professionals here in the room, one of the things that sort of lawyers are trying to do at the front end of the matter is trying to avoid any possibility of these disputes arising by drafting to the nth degree, trying to predict things which might happen. And you certainly see that in LNG, because of the relationship issue, which is why there haven't quite been as many disputes as certainly disputes lawyers would like. So, that's my short piece. I think I was about right in terms of time, but over to you, Hugh.